Let me explain it step by step in very simple terms. What are bailable and non-bailable offences? When someone is accused of committing a crime, the law divides crimes into two types. 1. Bailable offence, a crime where the accused person has the right to get bail. Bail means the person is allowed to stay out of jail by agreeing to certain conditions, like paying money or promising to attend court. Example, if someone steals a small item from a shop, it's a less serious crime, so it's bailable. 2. Non-bailable offence, a more serious crime where the accused does not have the right to bail automatically. In this case, a judge decides whether the person should get bail or not. Example, if someone commits murder, it's very serious, so it's non-bailable. How does the law decide if a crime is bailable or non-bailable? 1. The first schedule of CRPC, Code of Criminal Procedure. The law has a list called the first schedule, where crimes are marked as either bailable or non-bailable. 2. No fixed rule. There isn't a fixed formula to decide which crimes are bailable or non-bailable. It depends on how serious the crime is. 3. General rule. Serious crimes non-bailable, less serious crimes bailable. How seriousness of a crime is judged? 1. For crimes in other laws, not IPC, if the punishment for a crime is 3 years or more in jail, it's usually non-bailable. If the punishment is less than 3 years, it's usually bailable. 2. Exceptions exist. Some laws may make special rules about whether a crime is bailable or not. Examples to understand this better. 1. Bailable offence. Example, petty theft. Someone steals a chocolate bar from a shop. Punishment, less than 3 years in jail. It's a small crime, so the accused has the right to bail. 2. Non-bailable offence. Example, murder. Someone intentionally kills another person. Punishment, life imprisonment or death. It's a very serious crime, so bail is not automatic. A judge decides. Why is this division important? 1. Protecting society. For serious crimes like murder or rape, the accused is kept in jail to protect people. For minor crimes like a small theft, the accused can stay out of jail until the trial. 2. Fairness. Not all crimes are equally harmful. This division ensures that small mistakes don't lead to harsh punishments, but serious crimes are treated strictly. What is bail? Bail is when a person is allowed to stay out of jail while waiting for the court to hear their case. The accused may need to 1. Pay money as security. 2. Promise to appear in court. 3. Follow certain conditions, like not leaving the city. Comparison, bailable versus non-bailable offences. Bailable offence, non-bailable offence. Less serious crimes, more serious crimes. The accused has a right to bail. Bail depends on the judge's decision. Example, petty theft, public nuisance. Example, murder, rape, kidnapping. Extra points to note. 1. Judges can refuse bail even in bailable cases. If the judge believes the accused might run away or commit the crime again, they can refuse bail. 2. Purpose of bail. Bail is not meant to punish the accused. It's a way to make sure they come to court when needed. 3. In serious crimes, in non-bailable offences, the judge carefully checks whether releasing the accused will harm society or interfere with justice. Key takeaways. 1. Crimes are divided into 2 groups. Bailable offences, less serious, bail is a right. Non-bailable offences, more serious, bail depends on the judge. 2. The seriousness of the crime and the punishment decide whether it's bailable or non-bailable. 3. Bail is a way to balance fairness, not jailing people for minor crimes, and safety, keeping serious offenders in jail. Let me know if you want more examples or if any part is unclear. Let me break this down in the simplest way so you can fully understand it. What does this mean? It explains what happens when a person is arrested for bailable and non-bailable offences. It focuses on 1. Rights of the accused in a bailable offence. 2. What happens in a non-bailable offence. Breaking it down. 1. Bailable offence. What happens? If someone is accused of a bailable offence and is arrested or detained without a warrant, the person has a right to bail. This means the person must be released after they provide the required bail amount or personal bond. It is their legal right and the police or court cannot refuse. Example, Ravi is accused of trespassing, a bailable offence. He is arrested without a warrant. Ravi can immediately request bail. The police or magistrate must release him once the bail is paid. This is because bailable offences are not very serious. 2. Non-bailable offence. What happens? If someone is accused of a non-bailable offence, it's different. They do not have an automatic right to bail. Whether they get bail or not depends on the discretion of the court or magistrate. The authorities decide based on how serious the offence is, if releasing the person might cause harm or let them escape. Example, Ravi is accused of robbery, a non-bailable offence. He cannot demand bail as a right. The magistrate or court will look at the case and decide if Ravi should be released or not. If released, under what conditions, like strict monitoring or bond. Key difference between bailable and non-bailable offences. 1. Bailable offence. The accused has a right to bail. Authorities must release the person once bail is granted. 2. Non-bailable offence. Bail is not guaranteed. It depends on the discretion of the court. Why this difference? Bailable offences are usually minor crimes, e.g. public nuisance, trespass. The law assumes releasing the person won't harm others. Non-bailable offences are serious crimes, e.g. murder, robbery. The law wants to make sure the accused doesn't escape, commit more crimes or harm others. Summary. 1. If arrested for a bailable offence, the accused has the right to bail and must be released once bail is granted. 2. If arrested for a non-bailable offence, bail depends on the decision of the court or magistrate. 3. Seriousness of the crime determines how bail is handled. Let me know if you'd like further clarification or examples. Let's go step by step to make it even clearer for you. I'll explain what summons cases and warrant cases are, why they are important, and how they work in the simplest way possible. What are summons cases and warrant cases? The law divides criminal cases into 2 types based on how serious the crime is. 1. Summons case, a case about a less serious crime. Example, disturbing the peace, petty theft, or creating a public nuisance. 2. A case about a serious crime. Example, murder, robbery, or kidnapping. Definition. Summons case. A case that is not a warrant case. This means it involves small crimes. These crimes are usually punishable by less than 2 years of imprisonment. 2. Warrant case. A case involving serious crimes. These crimes are punishable by death or life imprisonment or imprisonment of more than 2 years. Why does this classification matter? The law classifies cases like this for 2 main reasons. 1. To decide the trial procedure. Summons cases have a simpler, faster trial process. Warrant cases have a longer, more detailed trial process because they deal with serious crimes. 2. To decide what to issue, summons or warrant. In summons cases, the court sends a summons to the accused. Like a summons is a simple notice asking the person to court. In warrant cases, the court may issue a warrant. A warrant is an order to the police to arrest the accused and bring them to court. Key differences between summons case and warrant case.
Summons commits crimes.
Seriousness of crime. Crime. Less serious crimes. Very serious crimes. Punishment involved less than 2 years of imprisonment. More than 2 years, life imprisonment or death. What is issued? Summons, notice to appear in court. Warrant, order to arrest the accused. Type of trial. Simple and quick, detailed and elaborate. Examples. Summons case example. A person is caught playing loud music late at night, disturbing the neighbours. The punishment for this is a small fine or a few months in jail. The court sends a summons to the person asking them to come to court. Warrant case example. A person is accused of robbing a bank. The punishment for this is more than 2 years of imprisonment. The court issues a warrant ordering the police to arrest the person and bring them to court. How do summons and warrants work? 1. Summons case procedure. The accused receives a summons, a written notice. The summons tells the accused to appear in court on a specific date. The trial is short and simple because the crime is not very serious. 2. Warrant case procedure. The court issues a warrant, an order for arrest. The police arrest the accused and bring them to court. The trial is long and detailed because the crime is serious. Why are warrant cases more detailed? Serious crimes, like murder or robbery, can have severe punishments, life imprisonment or death. The law must carefully check all evidence, listen to witnesses, and give the accused a fair chance to defend themselves. That's why the trial process for warrant cases is more elaborate. How does the court decide what to issue? 1. In summons cases, the court sends a summons because the crime is not serious. Example, if someone breaks a minor traffic rule, they receive a summons asking them to attend the court hearing. 2. In warrant cases, the court may issue a warrant because the crime is serious. Example, if someone is accused of murder, the court orders the police to arrest them and bring them to court. Important points to remember. 1. Summons equals less serious, used for crimes like disturbing the peace or petty theft. Trial is quick and simple. Only a summons notice is issued. 2. Used for crimes like murder, robbery or kidnapping. Trial is detailed and takes time. A warrant, arrest order, may be issued. Real-life scenarios. Let's say 2 friends, Rahul and Mohan, commit 2 different crimes. 1. Rahul summons case. Rahul is caught littering in a public park. This is a minor crime punishable by a small fine. The court sends Rahul a summons to come to court. Rahul attends court, pays the fine, and the case is closed quickly. 2. Warrant case. Mohan is accused of assaulting someone and causing serious injury. This is a serious crime punishable by more than 2 years of imprisonment. The court issues a warrant to the police to arrest Mohan. Mohan is brought to court, and the trial goes through a detailed process. Conclusion. Summons case. For less serious crimes, court sends a summons, notice. Trial is simple. For serious crimes, court issues a warrant, arrest order. Trial is detailed. This classification helps the legal system handle cases efficiently based on their seriousness. Let me know if you need further clarification or more examples. Let me explain this in even more detail, step by step, using the simplest words and examples so that it's crystal clear. What is Section 174 about? Section 174 explains what a police officer should do when someone reports a non-cognizable offence. Let's break it into small parts. Step 1. What is a non-cognizable offence? A non-cognizable offence is a minor crime. The police cannot arrest anyone or start investigating this type of crime without getting permission from the magistrate. Examples of non-cognizable offences: defamation, someone insults you publicly; public nuisance, someone makes a lot of noise and disturbs others; simple hurt, someone slaps you but it's not a serious injury. Think of it like this. For small matters, the police need to ask the magistrate before they can act. What should the police do? When someone comes to the police station and reports a non-cognizable offence, here's what the police must do. 1. Write it down. The police officer must write the details of the report in a special book kept in the police station. This book is like a record of all complaints about non-cognizable offences. The state government decides how this book should look and how the information should be recorded. 2. Refer the person to the magistrate. After writing the details of the complaint, the police must tell the person, called the informant, "You need to go to the magistrate to get permission for us to take action. Without the magistrate's permission, the police cannot investigate or arrest anyone." 3. Send reports to the magistrate. Every 2 weeks, fortnightly, the police station must send a report of all non-cognizable offences to the magistrate. This keeps the magistrate informed about the complaints being made at the police station. Why does this rule exist? 1. Prevent misuse of police power. It stops the police from unnecessarily interfering in small matters. 2. Ensure fairness. The magistrate acts as a supervisor to ensure that only genuine cases are investigated. Example to understand. 1. Imagine a situation. Ravi goes to the police station and says, "My neighbor insulted me in front of everyone." This is defamation, a non-cognizable offence. 2. What does the police do? The officer writes Ravi's complaint in the special book. The officer tells Ravi, "You need to go to the magistrate. Only the magistrate can give us permission to investigate this." 3. What happens next? Every 2 weeks, the police send a list of such complaints, including Ravi's, to the magistrate. The magistrate looks at Ravi's complaint and decides whether the police can investigate or not. What happens after the magistrate gives permission? If the magistrate gives permission, the police can start investigating the case. They can gather evidence, question people, and take action as needed. If the magistrate does not give permission, the police cannot do anything further with the case. Additional points to remember. 1. Why write it in a special book? It's a legal requirement so that all complaints are recorded properly. This prevents the police from ignoring any complaint. 2. Why send reports to the magistrate? It ensures that the magistrate knows about all non-cognizable offences in the area. The magistrate has the final say on whether the police can act or not. 3. What if the informant doesn't go to the magistrate? If the person, like Ravi, doesn't go to the magistrate, the police will not investigate the case. Summary: non-cognizable offences are minor crimes like defamation or public nuisance. 2. Police cannot act on such complaints without the magistrate's permission. 3. The police must record the complaint in a special book, tell the informant to approach the magistrate, send reports of these cases to the magistrate every 2 weeks. This system ensures that minor crimes are handled fairly and with proper supervision. Let me know if you want me to clarify anything further. Let me explain this step by step in the simplest way so you can understand everything clearly and easily. What are we talking about? This is about non-cognizable cases, which are minor crimes like defamation, insulting someone, public nuisance, disturbing peace, or trespass, entering someone's property without permission. Key point: the police cannot investigate such cases without permission from a magistrate. Breaking it down. 1. Rule: police need magistrate's permission. What does this mean? If a person reports a non-cognizable offence, the police cannot start investigating right away. They need an order from a magistrate, a legal authority. Without this order, the police are not allowed to take action. Example: if Ravi says, "My neighbour insulted me," the police cannot investigate until the magistrate says, "Go ahead and look into this." 2. What can the police do after getting the order? Once the magistrate gives permission, the police can investigate the case. They have the same powers to investigate as they would in a more serious, cognizable case. Exception: the police cannot arrest anyone without a warrant in a non-cognizable case, even after getting permission. Example: if the magistrate allows the police to investigate Ravi's complaint, the police can ask questions, collect evidence, visit the scene, but they cannot arrest the neighbour without a special warrant from the magistrate. 3. Rule: if a case has both cognizable and non-cognizable offences. Sometimes a case involves both types of offences. A cognizable offence, like theft, where the police can act immediately. A non-cognizable offence, like defamation. The whole case is treated as a cognized case. This means the police can investigate without waiting for the magistrate's order. Example: Ravi reports, "My neighbour insulted me," non-cognizable offence, "and stole my phone," cognizable offence. The police can act immediately because the theft is a cognizable offence. They don't need to wait for the magistrate's permission to investigate the insult part. Why these rules exist? To prevent misuse of police powers for minor issues. to ensure serious offences are prioritised, to provide a fair process by involving the magistrate for minor cases.
Aha!
Real-life examples to understand better. 1. Case 1. Only a non-cognizable offence. Someone reports, "My friend insulted me in public." The police must write down the complaint, tell the person to get permission from the magistrate, wait for the magistrate's order before investigating. 2. Case 2. Both cognizable and non-cognizable. A person reports, "Someone slapped me," non-cognizable, "and robbed my wallet," cognizable. The police can start investigating right away because robbery is a cognizable offence. Hack summary. 1. Non-cognizable case. Police need permission from a magistrate to investigate. Even with permission, they cannot arrest anyone without a warrant. 2. When there's both types of offences, if at least one offence is cognizable, the police can act immediately. Key points to remember. 1. Magistrate plays a key role in approving investigations for minor crimes. 2. Police powers are limited in non-cognizable cases. 3. If serious and minor crimes are combined, the whole case is treated as serious. Let me know if you want me to simplify or expand on any part further. Let's explain this section even more simply and clearly, step by step. Imagine you're learning this from scratch and I'm breaking down every part with examples. What does this section talk about? This section explains when and how police officers can investigate a cognizable case. It also says, 1. Police don't need permission to start investigating certain serious crimes. 2. More senior officers might handle very serious cases. 3. Nobody can later stop or question the investigation based on who did it. Step 1. What is a cognizable case? A cognizable case is serious crime where the police can 1. Arrest someone without asking a magistrate for permission. 2. Start investigating immediately. Examples of cognizable offences: murder, kidnapping, robbery, rape. Non-cognizable offences, for comparison: defamation, harming someone's reputation. Public nuisance, like loud noise at night. For non-cognizable offences, police need a magistrate's permission to investigate. Step 2. Who can investigate a cognizable case? Normally, the officer in charge of the police station in the area where the crime happened can start investigating. For serious cases, if the crime is very serious, like terrorism or organised crime, a senior officer like the Deputy Superintendent of Police, DSP, may take over the investigation. This happens when the Superintendent of Police, SP, orders it, considering the importance of the case. Examples. 1. Simple case. Ravi's shop is robbed. The local police officer starts the investigation immediately. 2. Serious case. A gang is involved in robbing multiple shops in the city. The SP may assign the DSP because it needs more expertise. Step 3. No permission needed for cognizable cases. The police do not need a magistrate's permission to start working on cognizable cases. They can collect evidence, question witnesses, and arrest suspects without waiting for approval. That's step 4. Serious cases handled by senior officers. If the case involves something very complex or critical, the SP can assign the investigation to a DSP or another senior officer. This ensures that the case is handled by someone experienced and capable of managing serious crimes. Example, if there's a murder in Ravi's town, the local police can handle it. But if the murder is linked to a criminal network, the SP may ask the DSP to take charge. Step 5. No challenges to investigation. Once the police start investigating, nobody can question or stop the process by saying, "This officer wasn't allowed to investigate." This rule protects the investigation from unnecessary delays or challenges. Example, after investigating Ravi's shop robbery, someone might claim, "This officer wasn't qualified to handle the case." The law says such arguments won't work. The investigation cannot be challenged like this. Why is this section important? 1. Quick action in serious cases. Police can start investigations immediately for serious crimes. 2. Proper handling of serious cases. Senior officers can step in for complex or critical cases. 3. Protects investigations. Nobody can stop or delay an investigation by questioning the officer's authority. Key points in simple words. 1. Cognizable cases. Police can investigate and arrest immediately, no permission needed. 2. Serious crimes. Senior officers like DSP may take charge if the SP decides. 3. No challenges. Investigations cannot be questioned later on who conducted them. Summary. This section ensures that 1. Police act fast for serious crimes. 2. Important cases are handled by capable officers. 3. Investigations are protected from unnecessary challenges. Let me know if you'd like even more examples or details. Let's simplify it even further, line by line, word by word, in the easiest way possible. What is being discussed? We are talking about how magistrates can order an investigation when someone makes a complaint, especially if it is about a public servant, like a police officer or a government worker. What is subsection 3? This part says, 1. A magistrate, a type of judge, can order an investigation in certain cases. 2. But they don't order it immediately, they follow a careful process. Step-by-step process for subsection 3. 1. A person applies to the magistrate. For example, someone might say, I think this crime happened and I want it investigated. 2. The application must have an affidavit. An affidavit is a written statement that the person swears is true. It's like saying, I'm telling the truth and I promise this happened. Example, if you saw someone stealing, you would write in the affidavit, I saw this person takes something from that shop on this date. 3. The magistrate checks everything. The magistrate might ask questions, do some inquiry to see if the complaint is genuine. Example, the magistrate may ask the police officer, is this complaint already being investigated? Is there enough evidence to start a case? 4. The magistrate listens to the police officer. If the police officer says something about the case, the magistrate listens to their side too. 5. Finally, the magistrate decides. If the magistrate feels that an investigation is needed, they will order it. What is subsection 4? This part talks about special rules for public servants, government workers like police officers or teachers. Step-by-step process for subsection 4. 1. A complaint is made against a public servant. For example, someone says, this police officer hit me unfairly. 2. The magistrate doesn't immediately order an investigation. They first check some important things. They ask the public servant's superior officer, boss or senior, for a report. Example, if a police officer is accused, the magistrate might ask the superintendent of police, what happened? Is the complaint true? B. They listen to the public servant's side of the story. Example, the police officer might say, I used force because the person was attacking me. 3. After looking at both sides, the magistrate decides. If the complaint seems genuine, they order an investigation. If it doesn't seem genuine, they might refuse. Why does this process exist? 1. To protect public servants. Public servants often have to make tough decisions during their work, like using force in certain situations. They shouldn't be harassed with false complaints. 2. To ensure fairness, the process gives both sides a chance to explain their version of events. Examples to help you understand better. Subsection 3. A shopkeeper sees someone stealing goods and files a complaint with the magistrate. The shopkeeper gives an affidavit saying, I swear I saw the person steal from my shop. The magistrate looks at the affidavit and might call the police officer to check if this case is already being investigated. After checking, the magistrate orders the police to start or continue the investigation. Subsection 4. A driver files a complaint against a traffic police officer saying, the officer fined me unfairly and insulted me. Before ordering an investigation, the magistrate 1. Asks the traffic officer's senior to submit a report explaining what happened. 2. Lets the traffic officer explain their actions. For example, the officer might say, the driver didn't have a valid license and they were arguing with me. After considering both sides, the magistrate might decide, if the officer acted unfairly, an investigation is ordered. If the officer followed the rules, the complaint is dismissed. Important terms to remember. 1. A judge who handles smaller or early stages of cases. 2. Affidavit, a written statement sworn as true. 3. Public servant, someone who works for the government like police officers, teachers or doctors. 4. Superior officer, a boss or someone higher in rank. Example, for a constable, their superior officer is the superintendent of police. Why are these rules important? They prevent abuse of power. They ensure public servants are protected but still held accountable. They make sure genuine complaints are investigated. Extra information. The Criminal Procedure Code, CRPC, is designed to balance justice for citizens and protection for public servants. Section 210 mentioned here ensures that if there are two cases about the same matter, one from the police and one from a private person, the magistrate combines them to avoid confusion. Final summary. 1. Magistrates have the power to order investigations, but they follow a careful process. 2. Public servants get extra protection to ensure they are not falsely accused. 3. The system is designed to ensure fairness for everyone. If anything is still unclear, feel free to ask, and I'll explain it further. Let's simplify this explanation even more so that it's crystal clear and easy to understand. What does this section mean? This is about how a magistrate, a type of judge, can order the police to investigate a case, but only after checking all the facts and evidence properly. The magistrate does this to make sure justice is served and no important complaint is ignored. Keywords to know. 1. Magistrate, a judge who handles small and medium-level criminal cases. Section 210, a rule in the law that allows a magistrate to manage cases where a private complaint and a police investigation involve the same matter. 3. Affidavit, a written statement where someone swears that their information is true. 4. Section 173(4), a detailed report the police create after finishing their investigation. How does it work? Step by step. Step 1. Someone submits an application to magistrate. What is the application for? The person is asking the magistrate to order the police to investigate. Example. Suppose Ravi's bike is stolen and the police didn't take action after he reported it. Ravi can submit an application to the magistrate saying, please order the police to investigate. Step 2. The application must have an affidavit. What is an affidavit? An affidavit is a written statement where Ravi says, I swear my bike was stolen and I have proof like a witness who saw the theft. Why is this important? It shows the magistrate that the application is serious and not fake. Step 3. The magistrate examines everything. The magistrate doesn't just order an investigation immediately. They first check, is the affidavit truthful? Is there any proof or evidence? Have the police already done anything about the case? How does the magistrate check? They can ask the police for updates or reports. They can question the person who submitted the application. Step 4. Magistrate's decision. After checking all the details, the magistrate decides 1. Order investigation. If the magistrate finds the application genuine and the police haven't done their job properly, they order the police to investigate. Example, if Ravi's bike theft was ignored by the police, the magistrate can order them to start investigating. 2. Reject the application. If the application is weak, e.g. no proof, false claims, the magistrate can reject it. Why is this important? It ensures justice by giving people a way to get help if the police don't act. It prevents misuse by ensuring that complaints are checked before ordering an investigation. Example situation. Case, a worker files a complaint that his wages were stolen but the police ignore it. Action, he submits an application with an affidavit to the magistrate saying, I have proof that my employer didn't pay me and kept my money. Magistrate's role. The magistrate checks if the affidavit is truthful. They ask the police, did you investigate this complaint? If the police did nothing, the magistrate orders them to investigate immediately. Connection to Section 210. If two cases are the same, sometimes there is a private complaint and a police investigation for the same crime. Section 210 allows the magistrate to combine both into one case, so there's no confusion or duplication. Final takeaway. 1. A magistrate can order the police to investigate if someone submits an application with proof, affidavit. 2. The magistrate checks everything before making a decision. 3. This process helps ensure justice and stops fake complaints. 4. Section 210 helps avoid confusion when there are overlapping cases. If you need more details or examples, let me know. I'll explain further. Alright, let's break it down step by step in the simplest possible way so anyone can understand. What is this about? This section explains how to report serious crimes, called cognizable offences, to the police and what the police must do after getting the information. Key terms. 1. Cognizable offence. These are serious crimes where the police can arrest someone and start an investigation without needing permission from a magistrate. Examples: murder, theft, rape, kidnapping. 2. Officer in charge of a police station, the head officer, usually called the station house officer or SO, who is responsible for handling reports and investigations. 3. Information, the details about the crime that someone gives to the police. What does this section say? 1. Anyone can report a cognizable offence. If a serious crime happens, you can report it to the police officer in charge of a police station. It doesn't matter where the crime took place. It could happen in a different city and you can still report it at your nearest police station. 2. How can you report the crime? Orally, by speaking. You can tell the police about the crime by talking to them. The officer must write down what you said. After writing, the officer will read it back to you to confirm it is correct. In writing, if you give a written report, the officer will accept it. Electronically, you can also report the crime through modern means like email, text messages, or apps, depending on what the police allow. 3. What happens after the information is written down? The person reporting the crime, called the informant, must sign the document. This confirms that the information recorded is correct and was given by them. Why is this important? 1. Everyone gets a chance to report a crime. Whether you talk to the police, write a letter, or send a message online, the police must listen and act. 2. The report is official. By writing it down and signing it, there's a proper record of what you told the police. This avoids confusion or denial later. 3. Accountability for the police. The officer cannot ignore your report. They must record it and take steps to investigate. Example to understand. 1. Oral report. You see someone stealing a car. You go to the nearest police station and tell the officer about it. The officer writes down your story, reads it back to you, and asks you to sign it. 2. Written report. Ravi writes a letter to the police saying someone broke into his house last night and stole jewellery to the police, who register it as a complaint. 3. Electronic report. Anita emails the police about someone hacking into her bank account. The police receive the email and treat it as an official report. Final summary. 1. If a serious crime happens, anyone can report it to the police. 2. You can report it by speaking. The officer will write it down. In writing, you give the details directly, electronically through email or other means. 3. After the report is recorded, you need to sign it to make it official. This ensures that every crime is properly documented and the police have the information they need to investigate. Alright, let's break this even further into tiny, easy to understand pieces, step by step, as if you're hearing this for the very first time. Here's the full explanation. 1. What is this all about? This rule explains how police must handle information about crimes when the complaint is made using electronic communication, like messages or email. A woman is the victim of certain crimes. It makes sure the process is clear, fair, and sensitive to people's needs, especially women. 2. What is electronic communication? Electronic communication means technology, like email, text messages, WhatsApp or similar apps, any other method that uses a phone or computer. Example, you send an email to a police officer saying someone broke into my house and stole my things. That's electronic communication.
3.
What must the police do when a complaint is made electronically? If someone reports a crime electronically, the police officer must do the following. 1. Write it down or keep a copy. The officer will take what you said in the email or message and write it on paper or print it out. 2. Get it signed within 3 days. The person who made the complaint, you, must come to the police station within 3 days and sign it. This confirms that the information is correct. 3. Record the details in a special book. The officer will write the main points of the complaint, like your name, the crime, and the date, in a book. This book is designed specifically to keep a record of complaints. Example, you send a message saying, "My bike was stolen." The officer writes this down and asks you to visit the police station to sign the complaint within 3 days. Then the officer enters this information in a register, special book. 4. What if a woman reports a crime? If a woman is the victim of a crime and reports it, the rules are different. Here's what happens. 1. The officer handling the case must be a woman. A woman police officer or a woman officer will handle her complaint. This ensures that the woman feels safe and comfortable talking about her problem. Why is this important? Women might find it difficult to share details of crimes like harassment or assault in front of male officers. A woman officer can make her feel more secure. Example, if Neha reports that she was harassed, a woman officer will listen to her and record the details of the complaint. 5. What crimes are included in this rule? This rule applies to crimes mentioned in certain sections of the Bharatiya Nyaya Samhita. These crimes are serious and include things like physical assault, theft, harassment, kidnapping, sexual abuse, domestic violence. Why do we need these rules? This rule exists to 1. Make sure electronic complaints are handled properly. 2. Ensure women feel safe when reporting crimes. 3. Keep a record of all complaints so nothing is missed. 7. How does it work? Here's the process, step by step.
A.
Complaint through electronic communication. 1. Someone sends a message or email to the police about a crime. Example, someone broke into my shop. 2. The officer writes down the complaint. 3. The person comes to the police station within 3 days to sign it. 4. The officer records the details in a register. B. Complaint by a woman if she is the victim. 1. A woman reports a crime like harassment or assault. 2. A woman officer listens to her and records the complaint. 3. The officer writes down all details carefully and makes sure she feels safe. 8. Real life example. Let's imagine 2 situations to help you understand better. Example 1. Complaint through email. Rajiv sends an email to the police. Someone stole my phone. The officer reads the email, writes it on paper and asks Rajiv to come in and sign it within 3 days. Once Rajiv signs it, the officer notes the details in a special register. Example 2. Complaint by a woman. Priya is harassed on the street. She calls the police station to report the incident. A woman officer listens to Priya's complaint, writes it down and ensures Priya feels comfortable. The details are recorded properly to start an investigation. 9. Why is this important for women? Women often hesitate to report crimes because they feel unsafe or uncomfortable. This rule ensures women officers handle their cases, making the process easier for them. 10. Key takeaways. If a crime is reported electronically, it must be written down and signed within 3 days. If a woman reports a crime, a woman officer must handle the case. These rules make sure every complaint is treated properly and fairly. If you have more questions or want more examples, let me know. Let's break this for tiny, easy to understand steps, word by word, line by line. Think of it as if you're learning it for the first time. I'll explain every single detail so it's crystal clear. 1. What is this rule about? This rule is about how the police must help disabled victims, mentally or physically, when they want to report a crime. It ensures the process is easy, comfortable, and respectful for the victim. Special steps are taken to make sure the victim gets the support they need. Have 2, who are disabled people. A disabled person is someone who, 1 has mental challenges, problems with memory, understanding or thinking. 2 has physical challenges, problems with walking, speaking, seeing or hearing. Examples: a person who cannot walk after an accident, physical disability. A person who has memory loss or finds it hard to understand things, mental disability. TAF 3. When does this rule apply? This rule applies if the victim, 1, is mentally or physically disabled, 2, wants to report a crime mentioned in specific sections of the law, like harassment, theft or assault. 4. What must the police do? When the disabled victim wants to report a crime, the police must follow these steps. Step 1. Go to the victim's chosen place. The police cannot force the victim to come to the police station. Instead, the police must go to the victim's house or any place the victim feels comfortable. Example: Ravi, who uses a wheelchair, cannot visit the police station. He asks the police to come to his house. They must visit him there to record the complaint. Step 2. Bring help if needed. If the victim cannot speak or understand well, the police must bring 1. An interpreter, someone who can help the victim speak in a way the police understand. Example: a sign language interpreter for someone who cannot hear or speak. 2. A special educator, someone trained to help mentally disabled people explain their thoughts. Example: Sita, who has a mental disability, reports a theft. A special educator helps her explain what happened so the police can understand.
Step 3.
Record the information on video. The police must videotape the entire process. This video ensures the victim's words are not changed or misunderstood. The video also acts as proof of what the victim said. Example: when the police visit Ravi's house, they make a video while he explains his complaint. This video becomes part of the case. Step 4. Get the statement recorded by a magistrate. After recording the complaint, the police must take the victim to a magistrate. The magistrate is a judge who will officially record what the victim says. This step makes the statement legal and valid for use in court. The police must do this as soon as possible after recording the complaint. Example: after Ravi explains his problem, the police take him to a magistrate. The magistrate records his statement in an official way.
5.
Why is this rule important? This rule is important because 1. Disabled people may struggle to visit the police station. Going to their home or chosen place makes it easier for them. 2. Special help ensures their voices are heard. Interpreters and special educators make sure the victim can explain clearly. 3. Videotaping protects the victim's words. It ensures no one can twist or change what the victim said. 4. The magistrate's recording adds legal strength. The victim's statement becomes official and can be used in court. 6. A real-life example. Let's look at a complete example. Ramesh is a man with a hearing disability. He cannot speak or hear. Someone stole his money and he wants to report it to the police. Step 1. Ramesh cannot visit the police station, so he asks the police to come to his house. Step 2. The police bring a sign language interpreter to help Ramesh communicate. Step 3. The police record Ramesh's complaint on video while he explains with the interpreter's help. Step 4. The police take Ramesh to a magistrate who officially records his statement in a legal way. Now Ramesh's complaint is valid and ready for further investigation. Nashtra 7. Key points to remember. 1. Police must go to the victim's house or a place they choose. 2. Interpreters or special educators must be present if needed. 3. The entire process must be videotaped for accuracy. 4. The victim's statement must be recorded officially by a magistrate. If anything is still unclear or you want more examples, let me know. Let's go step by step and explain everything in more detail using the simplest words possible so that even a beginner can understand it perfectly. What is this section about? 1. Subsection 2. After a person gives information about a crime to the police must give them a free copy of the recorded information. 2. Subsection 3. When a serious crime, punishable by 3 to 7 years of jail time, is reported, the police must follow certain rules before starting an investigation or action.
Subsection
2. Giving a free copy of the complaint. What happens? If you report a crime, the police will write down your statement or information. After recording it, they must give you a free copy of it. Why is this important? This ensures you have proof that the complaint was recorded. If the police don't act later, you can show this copy as evidence that you reported the crime. Example, let's say Mira reports a robbery to the police. 1. The police write down all the details she provides. 2. After finishing the recording, they give Mira a free copy of the written complaint. 3. Mira keeps this copy as proof that she informed the police. Subsection 3. What the police do for serious crimes. What are serious crimes? These are crimes where 1. The punishment is at least 3 years of jail, but 2. Less than 7 years of jail. Examples of serious crimes. Cheating, when someone tricks you to take your money or property. Causing serious harm, if someone injures you badly but does not kill you. What steps must the police take for serious crimes? When such a crime is reported, the police cannot act immediately. They must follow these steps. Step 1. Get permission from a senior officer. The officer in charge of the police station must first get approval from a senior officer. The senior officer must be at least of the rank of a Deputy Superintendent of Police, DSP or higher. This ensures the decision to act on the case is supervised by an experienced officer. Why is permission important? This rule prevents misuse of power. For example, the police cannot randomly act on false complaints without proper checks. Step 2. 2 choices after permission. After getting approval, the police can do one of 2 things. Choice 1. Conduct a preliminary inquiry. If the police are not sure if the crime really happened, they will do a quick check preliminary inquiry. This is like verifying the facts before starting a full investigation. This inquiry must be finished within 14 days. An example, Ravi reports that his neighbour cheated him in a business deal. The police are unsure if Ravi is telling the truth, so they do a preliminary inquiry to check facts, e.g. looking at documents or talking to witnesses. If they find the complaint is valid, they proceed further. Choice 2. Start an investigation immediately. If the police already see that there is enough evidence, prima facie case, they start a full investigation. Prima facie case means, at first glance, it looks like the crime happened. Example, Priya reports that someone broke into her house and stole money. The police find broken locks and fingerprints at the scene. This is enough evidence to show a prima facie case, so the police start the investigation immediately. Why these steps are important? For victims, ensures the police don't ignore their complaints. Victims also get a free copy of the report as proof. For the police, prevents them from acting on false complaints without proper checks. For justice, ensures serious crimes are handled carefully, either by verifying the complaint first or starting an investigation when there's clear evidence. Complete example to understand the process. Let's imagine a detailed scenario. 1. Crime reported. Ramesh reports to the police that someone cheated him in a property deal. 2. Free copy. The police record his statement and immediately give him a free copy of it. Serious crime. Since cheating is punishable by 3 to 7 years, the police treat it as a serious case. 4. Get permission. The officer in charge of the police station gets approval from the DSP to take action. 5. Preliminary inquiry. The DSP suggests a preliminary inquiry to check if Ramesh's claim is true. 6. Result of inquiry. The police find that the documents Ramesh provided are fake, confirming his complaint is genuine. 7. Investigation. After verifying the complaint, the police start a full investigation to collect more evidence and catch the accused. Key points to remember. 1. Free copy. The person reporting the crime always gets a free copy of their recorded complaint. 2. Serious crimes. Crimes punishable by 3 to 7 years need extra steps before investigation. 3. Permission. The officer must get approval from a senior officer before acting. 4. 2 options. preliminary inquiry within 14 days, immediate investigation if there's enough evidence. If you need any part explained further, let me know. Let's break this down step by the simplest way, as if explaining to someone with no prior knowledge. What is this rule about? It explains what a person can do if the police officer in charge of a police station uses to register their complaint about a serious crime called a cognizable offence. What is a cognizable offence? A cognizable offence is a serious crime where the police can act, like investigating or arresting someone, without needing permission from a magistrate. Examples include murder, theft, robbery, or assault. What happens if the officer refuses to register the complaint? If the officer in charge of the police station refuses to record the complaint, the person who wants to report the crime, called the aggrieved person, can take the following steps. Step 1, write to the Superintendent of Police, P. 1. The aggrieved person can write details of the crime. This is called the substance of the information. It's a brief description of what happened. 2. They must send this written information by post to the Superintendent of Police, P, of the area. The SP is a senior officer who has the authority to supervise and ensure practice. Example, suppose Rajiv goes to the local police station to report a theft at his house. The officer refuses to register his complaint. Rajiv writes a letter to the SP explaining that thieves broke into his house and stole valuables. He sends this letter by post to the SP's office. Step 2, SP's responsibility. When the SP receives the complaint, 1. They check the information. They will read the letter to see if it describes a cognizable offence. If the SP feels that a serious crime has occurred, they will take action. 2. Two options for action. A. The SP may investigate the case themselves. B. The SP may ask a police officer to investigate the case. The officer who is asked to investigate will have the same powers as the officer in charge of the police station. Example continued. After receiving Rajiv's letter, the SP finds that the theft is a cognizable offence. The SP asks another officer to investigate the theft and ensure proper action is taken. This officer now acts as if they are in charge of the case. Step 3. If the SP doesn't act. If the SP also doesn't take any action, the aggrieved person can go to a magistrate. The magistrate is a judge who can give orders to the police to register the complaint and investigate the case. Example continued. If Rajiv doesn't get a response from the SP, he can file an application with the magistrate. The magistrate will review the application and may order the police to take action. Why is this rule important? This rule ensures that 1. No one can be ignored if they want to report a crime. 2. If a police officer refuses to act, the person has a backup option by going to the SP or magistrate. 3. It protects the rights of the victim and ensures justice. Complete example to understand the process. 1. Refusal at police station. Meera goes to the police station to report that her car was stolen. The officer in charge refuses to register her complaint. 2. Writing to the SP. Meera writes a letter to the SP explaining what happened and sends it by post. 3. SP's action. The SP reads Meera's letter and finds that her case is serious, a cognizable offence. The SP asks another officer to investigate. 4. If SP doesn't act, if the SP ignores Meera's letter, she can go to the magistrate. The magistrate can order the police to register her case and investigate. Key points to remember. 1. If a police officer refuses to record your complaint, you can write to the SP. 2. The SP will investigate themselves or ask another officer to investigate. 3. If the SP doesn't act, you can approach a magistrate for help, and this ensures justice, even if police refuse to act. If you have any doubts or need more examples, let me know.